Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 77 in the list of AOR leading cases, which is titled as In Re Article 370 of the Constitution. Now, it is one of the recent judgments that has been passed in 2023 and is dealing with the abrogation of Article 370 of the Constitution of India. Now, before we go into the judgment, before we unpack what the judgment is saying, there are some aspects that needs to be discussed. Now, the court in this case is deliberating upon asymmetric federalism. We know that Article 370 that is there in the Constitution of India, it starts with the it starts with the word temporary. So this word is a special provision. This provision is a special provision, but however, a temporary or transitional provision in the Constitution that is giving Jammu and Kashmir a unique sovereign status while other states do have a mandate to stick to the Constitution of India, to stick to the laws of India in totality. Jammu and Kashmir can make its own laws. It can exercise its autonomy over the laws, and but however cannot do so in the defense matters or the matters of foreign affairs. So you may remember that before 2019, when we used to read any kind of acts, when we used to read Contract Act or Limitation Act, the first section of these acts used to be like that this act applies to whole of India except the state of Jammu and Kashmir, because Jammu and Kashmir had its unique sovereign status, unique constitutional status. Now that was done because Jammu and Kashmir comes out as a land which was affected most by the post-partition effect. Now the special status that was given to Jammu and Kashmir by the constitution framers at that time, at the time of 1946 to 1949, when the constitution was being drafted, is a deliberate attempt to acknowledge that in India we do follow asymmetric federalism also. That is where the constitutional relationship, where the state center relationship where the state center relationship for one state is different from that of the other states that are there in the country. Now in India, it is a very well established fact. If we look at the statement made by Professor K.C. Viere, if we look at the cases of state of Rajasthan, state of West Bengal versus Union of India, we have come to the conclusion that in India, we do not follow a very strict federalism. Our federalism has also been classified as a quasi-federal system. So India does follow a federal structure, but it does not follow a symmetrical structure like that is being followed in US. So in our Indian legal system, some states do have more autonomy, or they have more special arrangements, like we see in 317 Jammu Kashmir, or maybe 371 when we talk of Nagaland, etc. These are the examples that the constitution framers are providing special arrangement or transitional arrangements due to historical reasons, due to cultural reasons as well. Now, this asymmetry helps in managing the diversity. It takes into account the history and the cultural reasons, but it also raises a question that can a union, when it comes to power, can these special arrangement, these transitional arrangement can be revoked, and if they can be revoked, what could be the possible grounds? So this is also one of the issues that we are going to explore in this judgment. However, asymmetric federalism has been deliberated upon in greater depth in this judgment by Justice Chandrachud, especially. Now, what is happening? The facts of the case goes like that. When we, read the word first, I'll take you through the Article 370 in the Constitution of India. Now, when we read the provision, it starts with temporary provisions with respect to the state of Jammu and Kashmir, which are self-explanatory, that the provision is coming out as a transitional effect, or the provision is coming out as a temporary effect. Now, what is happening in this case is that in August 2019, we remember what used to happen at that time. So the President of India is issuing a constitutional order. It was numbered as CO 272, and it basically talks of the interpretation clause in the Constitution of India, which is there in Article 367. Now the presidential order numbers CO 272, it stated that it applies to all the provisions of the Indian Constitution. It applies all provision of Indian Constitution to the Jammu and Kashmir, including Article 367, which is about the interpretation of the Constitution. Now, CO 272 also amended that interpretation clause, which is there in 367, so that reference to Constitutive Assembly of Jammu and Kashmir can be read as Legislative Assembly of Jammu and Kashmir, which was mentioned in Article 370. But however, there was no Legislative Assembly at that time. Jammu and Kashmir was under the President rule, and Parliament was exercising the power of the state legislature under Article 356 because emergency, state emergency or presidential rule was declared. Now what happens that when Parliament is the authority, legislative authority exercising the power, and there is no legislative assembly, now Rajya Sabha passes a motion. Rajya Sabha passes a motion that the Article 370 shall be ceased to operate. Okay, so now Rajya Sabha passes the motion, and just another day, just the next day, President issues another constitutional order numbered at 273, and now it is using the power under Article 370 clause 3 to declare all the clauses of Article 370, all the clauses of 370 for ceasing to operate, and it effectively thus abrogated the special status given to Jammu and Kashmir. Now pursuant to this constitutional order, when let's come back to the let's first discuss the trajectory of the events happening. Now, what is happening? President is first issuing the constitutional order 272, okay, by which interpretation clause has been amended so that legislative assembly can be read in place of the constituent assembly in Article 370. Now, at that time, Article 356 was in force in Jammu and Kashmir. We might recall that the then Mehbooba Mufti and the party at that time, they were not allowed to sit in the legislative assembly, and emergency rule was imposed in Jammu and Kashmir at that time. Now Article 356 was in force, and therefore all the exercise was being done by Parliament. So here in Parliament, Rajya Sabha passes a motion for abrogation of Article 370. Now this is happening on 5th of August in 2019, and just the day next, one more constitutional order is passed by the president, which is numbered at 273, and this is being passed on 6th August, saying with regard to complete session of complete seizing of effect of Article 370 coming into force, which basically abrogated the effect of Article 370, and therefore abrogated the special status of Jammu and Kashmir that was given to it by the forefathers of the Constitution. Now, pursuant to this, what happens after this happens? Pursuant to the 6th August Constitutional Order 273, what is happening? Parliament is passing the Jammu and Kashmir Reorganization Act of 2019, and it splits the territory of Jammu and Kashmir into two union territories, one that goes by the name of Jammu and Kashmir and another that goes by the name of Ladakh. Now, it was provided in the Jammu Kashmir Reorganization Act of 2019 that there will be a legislative assembly in Jammu and Kashmir, while the latter union territory, that is Ladakh, it shall be governed as all other union territories are governed in the country of India. Now, because this step happened in just 2 days, the overhaul happened in 2 days with respect to the status of Jammu and Kashmir, several petitions were filed arguing that these changes are unconstitutional. These changes are basically moved with the intent of abrogating Article 370, and can union itself, without consulting the parliament, without consulting the legislative assembly, can the union really go ahead and unilaterally remove Article 370, unilaterally abrogate Article 370? Now, the moot questions that are arising before the court in this case is, number one, that whether Article 370 is temporary in nature, whether its nature was really temporary, or what was its nature. Then the second question is, can we amend Article 367 to the extent that Constituent Assembly means Legislative Assembly, because that was being done by the Presidential Order number 272. And then can the President strike down Article 370 without taking the recommendation from the Constituent Assembly of Jammu and Kashmir? And is the Jammu and Kashmir Reorganization Act, that is bifurcating the state of Jammu and Kashmir into two union territories, namely Jammu and Kashmir and Ladakh, is it a constitutionally valid legislature or not? So these few questions were framed before the 5 judges bench in the in the Supreme Court, and it the way we discussed asymmetric federalism was discussed by Justice Chandrachud primarily in this judgment. Now, what is the conclusion? What is the answer to the issues that have been framed in this judgment? Goes like that. First finding of the court was that Article 370, because the provision itself is starting with temporary provision, the term temporary provision, it signifies the intent that the provision is temporary and it wasn't permanent. Okay, because it was a transitional provision, it did not become permanent just because the Constituent Assembly dissolved at that time. So the president, second issue was that whether president could issue such proclamations. It was held that they could issue such proclamations, those proclamations to 272, 273. Those are the valid proclamation, those are the very valid presidential orders, because the state was under the president's rule at that time, and parliament can act as the state legislature. And CO 273 was enacted, was ordered in the pursuance of the motion that was led in Rajya Sabha and was passed in Rajya Sabha. So it meant that because there was an emergency in that state, there was a president rule imposed in that state, then the constitutional order number 272 and 273 were valid because parliament was exercising the power under Article 356 of the Constitution of India, and hence the requirement was fulfilled, recommendation requirement was fulfilled, and president could validly issue such orders, constitutional orders number 272 and 273. Now, coming to the question that whether the reorganization of Jammu and Kashmir, whether it was valid under the constitutional scheme, the court is answering it in affirmative, because there is an abrogation of first, what is happening? There is an abrogation of Article 370. So the special status is being revoked. Now it was read that Jammu and Kashmir will be just same as the other states and other union territories of the Indian nation. And when the special status is revoked, Parliament can exercise its power under Article 3 of the Constitution of India, that provides that Parliament may by law decrease or increase or divide the areas between the state. And hence the Jammu and Kashmir Reorganization Act that has been passed in 2019, it is valid in the light of Article 3, as well as Article 356, which was imposing the president rule in the state, as well as the abrogation of Article 370, which is already declared to be valid by the Supreme Court of India in this case. Now, main focus part of this case, which I found very useful, which I found to be discussed, is asymmetric federalism. The court herein is acknowledging that asymmetric arrangements like Article 370, 371, some elements of 371 are valid features of Indian federalism, and these arrangements are not beyond the reach of constitutional change. However, now in India, asymmetry is a tool. It is a tool to, include diversity. It is a tool to acknowledge that there could be historical and cultural parameters that such kind of asymmetric federalism is provided. But then you cannot claim it as a fundamental right. It is not beyond the reach of constitutional change. And while India allows for a flexible federalism, it is also empowering the union to revise the relationship as long as the due process is followed, as long as the procedure is followed. However, can we now say that there is no asymmetric federalism in India? But the answer is a negative, okay? Because asymmetric federalism is still there. The concept of asymmetric federalism is not abolished. It is just that Article 370's asymmetry, which was given in Article 370, it was transitional in nature. It was starting with the word temporary. The drafters, the framers of the Constitution have used the word temporary in the article itself, and union did have a right to bring that phase to an end. So therefore, for Jammu and Kashmir, asymmetric federalism, the status given by it by virtue of asymmetric federalism seems to be revoked. But however, there are asymmetric provisions. For example, the procedure shall not be applying to tribal areas, Nagaland, Mizoram, etc. Fifth and sixth schedule protects tribal areas. These are valid, and these are, we are in a continuous manner respecting such kind of asymmetric provisions. And therefore now, because of the pursuance of the judgment in Jammu and Kashmir, which is coming in 2023, all the acts done were held constitutionally valid. The new act, Jammu and Kashmir Reorganization Act, was also upheld, and court also directed that assembly elections for Jammu and Kashmir to be held within next few months. However, this judgment is reinforcing the fact that India is a federal country, but there lies a strong unitary core, there lies a strong unitary center, and that cannot be ignored. Okay, so union retains significant power over the special state arrangements. It is what the court is emphasizing in this judgment. So therefore, Article 370 was held to be of a transitional, of a temporary nature. Presidential orders in 272, numbered at 273, were held in the valid exercise of power, and asymmetric federalism is valid. It is a ground, valid ground, but it is not unchangeable. You can change it depending upon the recommendations, the conditions to be followed. Now, the Constitution herein is giving the union to reshape the federal relationships when and how needed. That is also what the judgment is emphasizing. Thank you, everyone. This was for staying till here. This was it in the video of INRE Jammu and Kashmir reorganization, INRE Article 370 of Constitution. If you found this explanation useful, please like, share, and subscribe to the channel. You can also hit the bell icon so that you get the notifications easily. Thank you, everyone. Please stay tuned. Have a very nice day. And for any more information, for any more queries, you may write to me at legaldarshan@gmail.com. Thank you, everyone.